Well, we'll go ahead and start. Welcome everyone to the 2022 Arnold and Porter Government Contracts Moot Court Competition. My name is Victoria Christoph. I'm a visiting associate professor of law and the government procurement law fellow here at the law school. And I had the privilege of teaching this year's government contracts moot court class. It's a spring class that we teach every year. And before it was a class, it was a competition that dates back to the early 2000s. It's one of the premier events our law school has here. It gives our students a chance to hone their oral advocacy and writing skills in the area of government contracts. So we're so excited to bring that back in person this year. It's been about 2 years since we've had this event here live. It was over Zoom. And we cannot be here today without acknowledging the generous sponsorship of Arnold and Porter, who's helped made this competition possible. We're very excited because we have a distinguished panel here tonight that will be coming in shortly. I wanted to introduce them. First up, we have Judge Reyna of the Court of Appeals for the Federal Circuit. Judge Reyna was appointed in 2011. He had a very distinguished career prior to his time on the bench. He was a partner in the International Trade Group of Williams & Millen. He has also published 2 notable books in the area of trade law and has published various other articles concerning international trade and other areas of law. That's just a few of his accomplishments. Next up, we have Judge Richard Hertling of the Court of Federal Claims. He was recently appointed in 2019. Prior to his time on the bench, he served as of counsel in a public policy group in a prominent Washington law firm. Prior to that, he had a distinguished career in the government, which included years on the Hill working for various senators and senior staff positions. He also spent some time at the Department of Justice. Last up, we have Judge Brian Smith of the Armed Services Board of Contract Appeals. He was also recently appointed in 2021. Prior to that, he had a distinguished government career. He spent time in the National Courts Division at the Department of Justice. He also was Division Counsel and E-Discovery Coordinator at the U.S. Army Corps of Engineers in Honolulu, Hawaii. Nice place. And he was also Senior Trial Counsel at the Navy Litigation Office in D.C. So we're so excited to have him here. They'll be coming in shortly. Apart from our panelists, we have our great finalists here today. And I wanted to briefly introduce them to you all. First up, we have Dozier Gardner. He's a 3L. He served as a senior articles editor for the Public Contracts Law Journal and sits on the mock trial board. He was a legal intern at the Civilian Board of Contract Appeals in the fall of 2021. Very timely, given our problem tonight. And he's currently interning for Judge Dep't at the Court of Federal Claims. And he hopes to pursue a career in government contracts after graduating law school. Next up, we have Daniel Fazenic. He's a 3L, and he's currently clerking at, I hope I get this right, Polero Maza. Okay. And he'll be joining full-time after graduation. He is specializing in our concentration, government procurement. So for students out there, you can concentrate in government procurement here at GW. And he is a senior articles editor for the Public Contract Law Journal. They'll be representing the appellant tonight, the contractor. Over here, we have our appellees who will be representing the government. First up, we have Ms. Diksha Chhetri, who's a 2L. During her time in law school, she interned for the Honorable Barry Baskin of the California State Court. And this summer, she plans to attend the University of Augsburg student exchange program, where she'll be focusing on international economic law and cross-border securities. This summer, she'll be working also for the SEC Enforcement Group in Silicon Valley. And she hopes to concentrate on business and finance law. Last but not least, we have Ms. Odom, who's a 3L. She's a member of the Journal of Energy and Environmental Law, the Criminal Law Society, and the Environmental and Energy Law Association. She worked for the D.C. Superior Court and the Georgia Public Defender Council, and she hopes to return to Atlanta following graduation to continue her public interest work. Now, these are finalists, so what that means is they were the highest scoring competitors in our competition. We had our preliminary rounds last weekend, and they excelled. They made it to the top. That said, I would also like to point out all of our competitors did a great job. It was a very close competition this year, within points of each other, and many of the class members are here today, so I want to just congratulate the entire class for a job well done. Last but not least, I want to introduce you all to our student co-chairs. We have, first up, student co-chair Stuart Anderson. He's an LLM. He graduates this spring. He currently works at the Department of Veterans Affairs Office of General Counsel, but after finishing a short tour on active duty, he expects to start with the Department of the Navy Office of General Counsel, Naval Sea Systems Command. And behind me, who will be serving as a timekeeper, is Hahn. She is a 3L, also graduating this year, and concentrating in government procurement. She is currently clerking at Fox Rothschild, where she'll be joining as a first-year associate in the fall in their government contracts group. And these two competed last year, and they did exceptionally well. They made it to the finals and won Best Contractor Brief. And because of that, they were selected to help me this year run the competition, and they wrote this year's problem, and Jane wrote the bench memo. So they have been working really hard, been coming to class, giving great advice to the students, so job well done to them. Last but not least, I just want to put a disclaimer out there. The discussion and questions by the bench tonight is purely academic in nature and does not reflect the judge's views on the merits of this problem, which is a timely issue that could be litigated at one point down the future, in the future. So with that, we are going to start, and we're going to make this as realistic as possible. So like any argument before an appellate panel, we're going to have a roll call, or court call. So Stuart, please lead the way.
All right. United States Court of Appeals for the Federal Circuit is now open in session. God bless the United States and this honorable court.
Good afternoon. Please have a seat. We have one case scheduled for argument this afternoon. The case is it's Green and Clean Energy Corporation Appellant versus Secretary of the Department of Energy, Appellee, case number 2021-0123. Are the appellants ready for argument?
Yes, Your Honor.
Appellees?
Yes, sir.
Okay, appellants, you may proceed. When you come up, please state your name clearly so that we may know who you are.
Yes, Your Honor. And before I proceed, would you be comfortable with me removing my mask while
You
speaking?
may remove your mask while you argue. And I need to know, Mr. Gardner, how much time are you reserving for rebuttal? And who's going to be making the rebuttal arguments?
Yes, Your Honor. My co-counsel will be doing the rebuttal, and he will be reserving 2 minutes.
2 minutes.
Yes, Your Honor.
Okay.
And before I proceed, my name is Dozier Gardner, arguing on behalf of the appellant. May I proceed?
Yes.
May it please the court and good evening. My name is Dozier Gardner, and alongside my co-counsel, Daniel Figuenick, we will be representing the appellant, Green and Clean Energy Corporation. Today, I will be arguing before you on the Appointments Clause issue, and my co-counsel will be arguing the issue of severance. Before I begin, I just respectfully ask my co-counsel be allowed to reserve his 2 minutes for rebuttal. Thank you. Your Honors, today we respectfully...
One of the things we're looking at is the appointment of officers, correct? And we have both inferior officers and superior or principal officers. Tell me, what's the difference between the two?
Yes, Your Honor. The difference between the two is a principal officer is one who is delegated a significant amount of authority and is not subject to guiding principles of executives above them.
Who delegates the authority, the Constitution or statute?
It is delegated through the Constitution from the President, as they are the ones who are endowed with executing the executive branch's power. And the court has specifically noted there are 3 factors that a court should look at when they're determining the difference between an
before we get to opinions interpreting the scope, the Constitution itself defines the difference between principal and inferior officers as simply the way they are appointed, right?
That is correct, Your Honor. The Constitution does define them in that way. However, the courts and the opinions have delineated the differences between an inferior and principal officer.
But when creating a statute and specifically enumerating how an officer is to be appointed, doesn't Congress look at the Constitution and then provide for the appointment of either a principal or an inferior officer accordingly?
Yes, Your Honor, I would hope the Congress does look at the Constitution when determining what officers, what level of responsibility they're giving to an officer, making them an inferior or principal officer, and then.
I'm not even talking about responsibility, I'm talking about how they're appointed. If Congress wants to create a principal officer, they provide in their appointment description that they will be appointed by the President, confirmed by the Senate. Or if they want to create an inferior officer, they provide that that will not happen and that they will be appointed by the head of the agency or the President or the courts of law. I believe this is what the Constitution says. Isn't that right?
That is correct, Your Honor.
So can we infer from the CDA that Congress specifically meant to create inferior officers when it created the CDA, which then created the agency boards?
Yes, Your Honor. While one can infer that, the Supreme Court has laid out a series of factors that help the court specifically look at things beyond congressional intent, as the court has noted.
Are these the Edmund factors?
Yes, Your Honor. These are the Edmund factors.
Are those the only factors that, that come into play here?
Respectfully, no, Your Honor. While the Supreme Court in Edmund did specifically mention these three factors, and then again in Arthrex, these three factors were applied, the court did take pains to ensure there would not be a rigid test or a bright line to determine the difference. However, it is based on these three Supreme Court decisions and Arthrex as recently as 2021, where they only applied the three Edmund factors and specifically chose
So
not to look
what
at
would
others.
what would happen if we issued an opinion but never analyzed the Edmund factors? Would we be in error?
If this court, if I may just clarify, Your Honor, if this court issued an opinion invalidating the board judges for the appointments clause without addressing the Edmunds factors?
Whether we invalidate or not. Let's say we just skip it altogether and never mention the three factors. Would that be erroneous?
Respectfully, Your Honor, I do think it would, as the Supreme Court recently noted that this is the analysis the court should take when determining the line between inferior or principal officers. And looking at the opinion in Arthrex and going against these factors would lead the court down an area where the court has specifically said not to go, and they should be applying these factors. That being said, this is not a rigid test, and the court may indulge in other factors. However, given the recent opinion in Arthrex, where they only applied
Well,
these
you
specific
say it's not a rigid test, but yet we're required to apply the three factors.
Yes, Your Honor. Rigid as in the court is not required to only apply these three factors, and they are not required to apply them in narrow and rigid ways.
Where are the other factors? What are they?
There are no other factors that have been set out in stone, Your Honor, but Justice Breyer did mention in his concurrence two other factors, such as congressional intent and the practical consequences of the statute.
Justice Breyer's concurrence where?
In Arthrex, Your Honor, my apologies. And Justice Breyer mentioned the practical consequences of the statute along with congressional intent.
What do we mean by practical consequences? Are we setting policy here?
No, Your Honor, this would not be asking to set policy. However, Justice Breyer urges, and we suggest incorrectly urges, the court look at the practical consequences of the statute, such as, is the statute operating in the way that Congress wanted it to, or is it achieving the goals that were intended by the statute? However, the Supreme Court, specifically in Arthrex, with facts strikingly similar to the Civilian Board of Contract Appeals, the court there specifically noted that considering these extra factors, such as intent and practical consequences, was inappropriate, and we suggest here they are similarly inappropriate. Now, these three factors the court specifically did find appropriate to apply was, first, the power to review and reverse the decisions of officers. The court noted specifically in Arthrex that the power to review or reverse decisions from officers is a significant, although not dispositive, it is a significant factor weighing in favor of an officer being a principal officer. Here, the Civilian Board of Contract Appeals judges.
Why does it make a difference with respect to the power of review in situations where there's always judicial review? Doesn't the Administrative Procedure Act provide that there should be some form of judicial review of agency determinations?
Yes, Your Honor, that is correct. However, here, what the court in Arthrex addressed this question specifically, they said that in officers who are not appointed by the President, who are not considered principal officers, if their decisions are going to be entered on behalf of the United States and become binding, there has to be some review within the executive branch from a principal officer. This is to ensure that...
Of the agency?
Yes, Your Honor, it does not, the court has not specifically said it needs to be kept within that exact agency, but there needs to be some level of executive review of these decisions. And here, that is not present. The civilian board judges enter their decisions once they've made their decision, and then the only level of review that can be had goes outside of the executive branch and to the judicial branch. This is the similar scheme we saw in Arthrex, and the court noted that this is an inappropriate level of control for inferior officers to be considered principal.
Counsel, well, let me ask you this. Here's my concern with your argument. If I accept that the administrative judges on the board are unconstitutionally appointed, that leaves us with the contracting officer's decision being final. You've lost in front of the contracting officer. Where do you go from there then?
Yes, Your Honor, going from the contract.
If the board's not constitutionally composed, you're stuck, aren't you then?
Respectfully, Your Honor, contractors could then have their claims brought to the Court of Federal Claims. They could have their disputes going through ADR, and there are other channels that contractors may use to settle their disputes beyond the Civilian Board of Contract Appeals, and that is not the only place they can go. Now, returning to the...
Yeah, but litigation in the Court of Federal Claims is far more expensive than before the board. And so if it's a relatively modest contract, you're going to rack up a lot of litigation costs and take more time in front of the court than you would before the board. Isn't that right?
That is correct, Your Honor. However, we would suggest that parties are also able to, in front of the Court of Federal Claims, and my co-counsel will be able to address this slightly more in depth in the talk about severance. However, the Court of Federal Claims could utilize things such as mini-trials or ADR and use those procedures that would cost less and allow for contractors with more modest contracts to bring this before the court and not rack up these larger litigation
Okay,
costs.
now let me ask you this. If you lose in front of the contracting officer, as you have, as your client has, and you then have to go to the Court of Federal Claims, why aren't the contracting officers unconstitutionally appointed?
Yes, Your Honor.
If they're not subject to review by the agency head, if their decisions under the CBA are not subject to review either, why aren't they unconstitutionally appointed?
Yes, Your Honor. Here we suggest that contracting officers, although despite their name, do not fall under executive officers given the court's precedent on what constitutes an executive officer. Specifically, they do not exercise significant authority to be deemed officers and would rather be an employee of the executive, who is not required to conform to the appointments
Are
clause.
their decisions final?
These decisions are final, Your Honor, yes. However, a decision being final is not simply enough to make someone an officer of the
But
United
that
States.
is a factor, right? That's a characteristic of a principal officer.
That is a characteristic of a principal officer. It can be a characteristic of a principal officer, yes, Your Honor, or an officer. However, the Supreme Court in Freytag specifically looked at whether or not special trial judges exercise significant authority to be considered officers, and they noted specifically these special trial judges made rulings on admissibility of evidence, could enforce compliance with discovery orders, could take testimony, exercise discretion on fashioning remedies, and here, these judges could not enter final decisions. So the ability to enter a final decision is not dispositive and may not be present for an executive, someone within the executive branch, to be an officer or an employee. While it is something to consider, the fact that they can make final decisions in and of itself does not make them officers. And the significant authority, as compared to the factors in Freytag, does not rise to the level of an officer, be that inferior or principal.
But if we strike the board, then the contracting officer's decisions do become final, and the contracting officers themselves become effectively the final adjudicator within the executive branch. So why doesn't that vest them with the same authority that the board currently has, that you're telling us renders the board's administrative judges unconstitutionally appointed?
Yes, Your Honor. As I mentioned, since they are considered employees, the fact that they would become the final adjudicators and then the only review they could seek would be outside of the executive branch would not be an issue. Here the issue is when officers with this significant authority are exercising it, and they exercise this significant authority, and then that is taken outside of the executive branch. Here we suggest these officers, as Judge Flores mentions in his dissent on page 6 of the opinion of footnote, these officers arguably exercise significant authority, and Judge Flores notes that they are not in fact officers, and that they would require their own separate analysis to determine whether they are or not. And we suggest, as I have in my brief, that they are not within the meaning of the significant authority test the court has laid out in Freytag and Lucia.
So, assuming that we determine that board AJs are inferior officers, so what's wrong with that? What's the consequence of that decision?
Pardon me, Your Honor, if you find that they are principal officers?
Yes, inferior officers, that the board administration judges are inferior officers.
If the board judges are inferior officers, the issue there is that given the Arthrex and Edmund analysis, they are wielding power that is principally reserved for principal officers. And in wielding that power, they must be held accountable to the president, the ultimate executor of this executive power. And vesting inferior officers with this power contravenes the appointments clause in maintaining a chain of command down from the president to these lower officers.
Right, but if they're inferior officers, what, if anything, can you point to in the CDA itself that you would then say is somehow an unconstitutional gift of power to those inferior officers?
Yes, Your Honor, this does go back to the Edmunds factors, these unconstitutional grants of power, the ability to enter final decisions on behalf of the United States without any executive review, as was this case in Arthrex. Similarly, there is a lack of direction and supervision from any executive. As the court stated in Edmund, the Coast Guard JAG could promulgate rules of civil procedure for court of criminal appeals judges to follow. No similar level of direction is offered to the Civilian Board of Contract Appeals judges. Instead, they promulgate their own rules, amendments to the rules, and can delete their rules as they see fit.
And just to clarify, are we talking about the board itself as a body or each individual judge? Which one of those are you saying is quote-unquote unconstitutional?
The board judges, Your Honor.
All of them?
Yes,
Or
Your
one
Honor.
of them?
Yes, I apologize, I misunderstood the question.
Okay.
And the final factor is the power to remove. The Supreme Court has noted in Edmund and in Arthrex the power to remove, the unfettered power of removal is a strong tool for control. And having good cause or for cause removal prevents the president, through their principal officers, from properly maintaining a chain of command from themselves down to the
Is the
inferior
power to
officers.
remove, is that undertaken by procedure that's different from the uniform rules of procedure that you referred to on page 9 of your brief?
The uniform rules of procedure. I believe that was in reference to the Civilian Board of Contract
Correct.
Appeals rules. Yes, that is separate. The GSA administrator can, for good cause, recommend judges be removed, and that is sent to the Merit Systems and Protection Board, who then makes a determination whether they can be removed, which is the opposite of what the Supreme Court has said is an appropriate level of control. And I see my time has expired. May I just briefly finish, Your Honors?
Go ahead.
And it is for the foregoing reasons that all three Edmund factors weigh in favor of these judges being principal officers. We respectfully ask this court vacate and remand the decision of the Civilian Board of Contract Appeals. Thank you.
Okay, hold on just a minute. Any questions?
I may follow up on some of my questions with his co-counsel.
All right, thank you much. Let's hear from your colleague.
Thank you, Your Honors.
May I please the court? My name is Daniel Fazenic and I represent Appellee Green. Today, I take up the issue of severability, the appropriate remedy of relief for finding the board administrative judges unconstitutionally appointed principal officers.
So this issue that you're addressing, you address this on page 10 of your brief. Board AJs cannot be removed at will, correct?
Correct.
Okay, what, and you talk about a final Edmund factor that weighs in favor of the board, and that goes into removal. How much weight do we give if we find in your favor with respect to removal?
Would you mind clarifying the question, Your Honor? I apologize.
Okay. if we find in your favor of, in examining your arguments with respect to removal, how much weight do we give to whether an AJ can be removed, let's say at will or not? How much weight does this issue carry in view of the other Edmund issues, or Edmund factors?
Yes, Your Honor.
Do you understand?
I apologize. I believe that question would be best answered by my co-counsel. I don't think I would be prepared enough to answer this question regarding the evidence factors.
But it goes to severance, which is your topic, right?
Correct, yes.
So if we just sever whatever
Yes.
offending provision makes the CDA unconstitutional, the board can continue to do its work.
Mhm.
Couldn't we just sever the removal position of the CDA vis-a-vis the CPCA judges?
No, Your Honor. It is Green's position, and we suggest that removal of the severance of the removal, good cause removal protections at the CDA at 7105B3 is one distinguishable from previous severance precedent, finding that removal protections can be severed to create inferior officers. First, in Seal Law, LLC versus Consumer Financial Protection Bureau, severability of removal protection was allowed there, severing the removability of the director of the Consumer Financial Protection Bureau. However, there, the Supreme Court found that severability was okay, permitted, because there was an express severability provision in the statute, the Dodd-Frank Act. Here today, the Contract Disputes Act does not have such a clause, provision.
But isn't severance a judicial vehicle by which to make a offending statute, to fix it, if, to use that word?
Yes, severance is the judicial vehicle to fix a statute when there are problematic portions. U.S. v. Booker held the three-part test, actually. The Supreme Court stated that after severing problematic portions of a statute, the remainder of the statute must be 1, constitutional, 2, capable of functioning independently, and 3, consistent with Congress's main objective.
So then that's where we've been going.
Yes.
If we severed that one little line in the CDA that only applies to the CBCA versus the other 3 boards that are created at the same time, that is that removal that provides, as you accurately said, for an action in the MSPB against the perceived to be offending judge. If we just sever that one line, won't the rest of the CDA be constitutional?
Respectfully, no, Your Honor. Severance of the good cause removal protections would strike directly at the board's independence and the factor 3 of the U.S. v. Booker test.
But, well, hold on. I mean, there are 3 other boards
Yes.
that don't have that line that are created right alongside the CBCA. So wouldn't us severing that removal provision simply bring the CBCA in exact conformity with the ASPCA, the Tennessee Valley Board of Contract Appeals, and the Postal Board?
They would be, yes, Your Honor, they would be very similar after severance of that provision. However, Congress did not speak to it in the legislative intent as to why they included these good cause removal protections. And further, when determining whether to sever a statute, it's primarily a question of legislative intent. As I just mentioned, Congress has not spoken to it.
Well, let me ask you, counsel,
Yes.
because one thing Congress has spoken to is the CBCA is explicitly established in the GSA, right? That's section 7105B1. But in section 302A of Title 40, the Administrator of General Services is appointed the head of the General Services Administration. Taking the other tack from that my colleague's been pursuing, why don't we just simply, as the Supreme Court did in Arthrex, take out the prohibition on the administrator reviewing the decisions of the board before they go to the court for judicial review? Wouldn't that accomplish also if we sever the prohibition on the administrator's review? Don't we wind up with the same solution that the court came up with in Arthrex?
Thank you for your question, Your Honor. I'm not aware of any part of a statute where the GSA administrator is given the power to review.
He's not.
Okay.
He's not. But he, in fact, the statute prohibits him from reviewing. I'm saying we sever the statute, we take that line out of the CDA, to the line that forecloses the administrator from reviewing the board's decisions. If we strike that, then as the administrator for general services, the administrator would, in the due course of his responsibilities or her responsibilities, review the board's decisions. Why isn't that constitutional?
Yes,
And
Your
why
Honor.
wouldn't that save the CDA?
Yes, Your Honor. And I believe it comes back to the question of congressional intent. Congress intended for the Civilian Board of Contract Appeals to be independent and quasi-judicial form. The Commission on Government Procurement set out to resolve an inequitable disputes process. Striking or severing that provision, as you mentioned, giving the Civilian Board of Contract Appeals their decisions to be reviewed by the GSA administrator would, one, create a weaker and less legitimate Civilian Board of Contract Appeals, and just another step in the bureaucratic disputes process, as well as, excuse me, well, that is the point is, excuse me, the severing such a provision would create a less independent board, which is directly contradictory to the legislative intent of the.
So what is it that you would like for us to sever? What part of the statute?
It is Green's position that the entire Contract Disputes Act would have to be invalidated. We believe that the Civilian Board of Contract Appeals language within the statute is too pervasive to just sever a slim portion. Severing
Okay,
it
assume we don't rule on your behalf on that argument. What's the next best step for you?
the next step for our client.
Or outcome? What's the next best outcome?
It would be to, if you do not rule and you decide to sever the statute, and allowing the civilian board to continue operating? Is that the question?
Well, that's what I'm asking you.
Okay, no, yes, thank you. I believe that our contractor would have its claim was, the board's decision would stand and our contractor's claim would have been denied.
Okay.
But I want to come back to, again, this is what perplexes me. You're trying to strike the board down, and you just said, if you win, the whole CDA goes away, at least insofar as the CBCA exists. It doesn't affect the other boards that are created. So you're left with the contracting officer's unreviewable decision. How does that benefit you? How does your client get something out of, if you strike the whole system? You're left with a final decision by the contracting officer, and then the only choice you have is to go to the Court of Federal Claims, which is more expensive and takes longer to litigate. I just don't understand how that benefits your client or contractors who are similarly situated to your client.
Yes, Your Honor,
And this goes, by the way, it's not a frivolous question, it's not an egghead question. You're telling us that we shouldn't sever any part of the statute because the statute has to rest as a whole. But I'm concerned that view is myopic because Congress had other interests in mind, not simply creating an independent review in the CBCA, but giving contractors a less expensive, more expeditious mechanism for resolving contract disputes other than having to go through the formalities of the judicial forum. So explain to me how your approach helps the contracting community.
yes, Your Honor. The approach would help the contracting community because if the severability would come up if the board administrative judges were found unconstitutionally appointed. We'd be dealt a Contract Disputes Act that is unconstitutional. This unconstitutional violation has to be fixed by the Congress, the legislators. It would create a constitutional government procurement system.
Why does it have to be Congress? Why can't we do it?
Yes, Your Honor.
We did that under Arthrex, correct? And the Supreme Court did too. They applied the doctrine of severability and they removed the offending part of the statute.
Yes, Your Honor.
Why can't we do that in this case?
And isn't that better for not only your client, but the entire contracting community?
Thank you for your question, Your Honor. Regarding US v. Arthrex and the severability portion there, the decision here today, the facts here today are distinguishable from that of.
You got 2 minutes left, and you got rebuttal time for 2 minutes. Ma'am, is he into his rebuttal time now? Is that 2 minutes total time? Okay. Go ahead and answer the questions, and I'll restore your 2 minutes of rebuttal time back, all right?
Okay. Thank you, Your Honor.
Do you have a question you can ask?
It would be, today we are unable to sever the statute because severance is appropriate remedy when via using the three-part Booker test. Congressional intent is independence in quasi-judicial form. In US v. Arthrex, there were two provisions present in the statute, Title 35 of the US Code, Section 6, that are not present here today in the Contract Disputes Act. In Arthrex, there was one provision granting the administrative patent judges independence from review, and two, it gave the director of the PTAB the power, the director of the Patent Trials and Appeals Board, the broad power to review administrative patent decisions. Both provisions are unfortunately not here today. Facial invalidation.
Okay, well, kind of wind it up now.
Yeah, thank you. Facial invalidation of the Contract Dispute Act is the proper remedy for relief here today. Severing any of the problematic provisions would leave a statute inconsistent with congressional intent in enacting the Contract Dispute Act. And for the foregoing reasons, we respectfully request that the court vacate and remand this board's decision. Thank you.
Okay, thank you.
Good evening, everyone, and may it please the court. My name is Diksha Chhetri, and I, together with my co-counsel, will be representing United States government in this matter. As we heard, there are two issues involving this matter, and I will be discussing issue number one, that is whether the appointment process of the civilian board's administrative judges is unconstitutional because they are principal officers, and therefore the president should appoint these officers by and with the advice of the Senate. The answer to this question is no.
I'm gonna ask you the same question I asked the other side. Is it necessary that we apply the Edmund factors? If we don't, if we issue any decision going one way or the other, and we fail to analyze or apply the Edmund factors, have we committed error?
No. And we believe that this is the specific case where the court should not restrict itself to Edmund three-part test. Should look at it, however, there are several other factors that we need to consider because of the facts of the case.
Well, one of the things that you heard me ask your opponents about was simply the reading of the CDA itself and the indication that the judges of all four agency boards are supposed to be treated in parallel with administrative law judges who are unquestionably inferior officers. If we simply write what I just set up as an opinion, is that going to be sufficient to withstand another challenge to our reasoning?
Can you repeat that question?
Yeah, Judge Reyna was asking about the Edmund factors, and he wonders whether we have to rigorously apply the Edmund factors and discuss each one and make a decision about how each one lies versus, and I gave an example, finding a different reason to determine that the CBCA judges are inferior officers. And I gave an example of one, so can you answer that question?
So you were asking if we look at the CDA and the intent?
Mm-hmm.
Yes, and I think the CDA, the Congress with CDA intended these officers to be inferior officers for the purposes of the appointment clause because they appointed GSA administrator as a superior officer to appoint these officers and remove these officers for good cause.
I I was focusing on the actual language of the CDA itself, the statutory language. Is there something in the legislative history? I know you quoted some of it in your brief. Is there something else in the legislative history that goes to whether Congress intended for judges to be principal or inferior officers?
Yes, so the CDCA, and I quote, says, to the fullest extent practicable, informal, and inexpensive resolutions of the dispute. It was created so that we get, contractors get informal, practicable, and inexpensive resolution of the dispute. If we make these officers principal officers, one or two outcome will follow. Either the board get dissolved, and then the contractor, as the court discussed, would have to go to the federal court, the Article 3, in front of Article 3 judges. And as we have discussed so far, it's not informal, it's not practicable, and it's very expensive. And if, on the other hand, the president do the nominations, then I would like to point out how extensive the process of nomination is. There are rules that the GSA administrator would follow. They maintain a register of candidates that can be the judges.
Why should we be concerned with all of that? I mean, if we see that we need to take certain action, why should we be concerned in this case, for example, with these consequences you're talking about, if at the same time you're arguing that we don't even have to consider the Edmund 3 factors?
Respectfully, Your Honor, we should consider Edmund's 3 factor, but we should not only consider those 3 factors. And
Well, you argue in your brief at page 12 that the Edmund factors are not dispositive.
yes.
What do you mean by dispositive in this particular case?
What I mean by dispositive is that's if we, like the court below, I would say, erred in only applying Edmund's factors and not going beyond that. That's what I mean, that we should not limit ourselves to only those 3 factors, and we should take a look at what Morrison Court did.
So if they're not dispositive, and now you're arguing these other consequences, then you're arguing that we should put more weight on these other factors, the Justice Breyer factors, than the Edmund factors?
Yes, I am arguing because of the facts of this case, and I'm arguing because Edmund Court itself discussed Morrison's factors and refused to apply it because the facts were different. Here, we believe that the facts are similar to what we had in Morrison v. Elson, and that's in and itself is a good enough reason to look beyond Edmund's 3-part test and consider what Morrison Court did when they did their appointment clause analysis.
Well, counsel, what perplexes me, and as I've read the briefs, I've read Edmund, I've read Morrison versus Olson back when it came out, and again, to prepare for this argument. But what strikes me about your argument and your brief is the paucity of references to Arthrex, the Supreme Court's most recent pronouncement on the question. Why isn't Arthrex dispositive of this case for the appellants?
2 reasons, Your Honor. First, because Supreme Court never said so.
Never said what?
That it's dispositive.
Well,
And
no,
Arthrex
because the
or Edmund-
CBCA wasn't in front of the Supreme Court in Arthrex. But the PTAB judges are very similarly situated to the administrative judges in the Civilian Board of Contract Appeals. The two look very similar to me. Why doesn't Arthrex dispose of your argument here?
I respectfully disagree that they're similarly situated because the PTO director, would never come as a party in front of PTAB judges as a party. And here, the GSA administrator who houses CBCA as agency could potentially come as a party in front of these judges. And therefore, I would say that Arthrex is different than what we have here. brings me to my second point, that even though the court below treated Edmund's three-part test as dispositive, we should not do so, and we should look beyond the Edmund's three-part test and pay attention to the standard established in Morrison v. Elson and the functional test.
Well, but we shouldn't ignore Edmonds altogether, we should just add additional factors, is that what you're saying?
Yes.
Okay, so part of the reason you're arguing that is because you recognize that there's some vulnerability if within the three tests that Edmonds applies, right?
Yes.
One of them is the final decision.
Mhm.
Within the executive branch, you concede that once the CBCA has made a decision, there is no further recourse in the executive branch, although there is before the Court of Appeals.
Yes.
Right.
Yes. So part of what we believe is not that Edmund test is bad, but we cannot apply that test to this case because of the conflict of interest that I just mentioned. If we have a principal officer rigorously
It's not
oversighting,
bad, but it doesn't help you, that's what you're saying.
it cannot be applied, practically speaking, because if we have a principal officer who can invalidate the decision of these judges and rigorously review the decision of these judges, then it would defeat the purpose of their job. If GSA as a party would come in front of these judges and the GSA, whatever decision that the judges would render, the GSA could invalidate that decision,
Well,
then this
that
would make the judges
distinguishes,
hesitant.
that's a legitimate distinction with Arthrex, but I don't see how it helps you get around Edmund. Edmund was the Coast Guard Criminal Appeals Board, and the reviewing official there is the Judge Advocate General of the Coast Guard. His lawyers are litigating every single case that comes before the Criminal Appeals Board for the Coast Guard. So I don't see that distinction saves you from the application of the Edmund test.
So in Edmund test, the principal officer was Secretary of Transportation, and the judges that were appointed were discussing appeals from court martials.
Mm-hmm.
And then, so the Secretary of Transportation would never come as a party in front of these judges because they were essentially reviewing cases from the appeal court, from the court martials.
Right, but the court martial is the Coast Guard court martial, and the Coast Guard reports to the Secretary of Transportation. So he's their boss. He's the same as the PTO director in Arthrex.
Yes, but here, the government could come as a party. There, it potentially could never come as a party in front of these judges, the Secretary of Transportation, even though it's the head of the department.
Courts martial are prosecuted by the Coast Guard. The United States is prosecuting the Coast Guard's personnel before a court martial. So you have the United States is always prosecuting the case. That's why I say it's a legitimate distinction with Arthrex, where the PTO director is not going to be litigating in front of the PTAB. But Edmund, the United States is involved in every single case.
I understand, and let me clarify. When we appeal a decision from district court to circuit court, or it's always that the United States is a party. However, we are appealing the decision of the court. Now, this case, we are not appealing a decision. In the matter that we have, the United States is a party fighting for their right, saying that they're right. It's not United States' decision that the judges decided on behalf of the United States. It's the United States as a party coming that they are correct. And that's different. And that's why this case is different than what we have done or discussed so far when it comes to appointment clause analysis. I would like to start how we have discussed how this case is different and how we need to move beyond the Edmunds three-part test and look the factors that Morrison v. Elson court considered for the reasons that we do not want a principal officer to pressure the superior officer. Like the case in Morrison v. Elson, the court ruled that there is some level of independency that is needed because in Morrison v. Elson, the special counsel was prosecuting high-ranked public officers, and these high-ranked public officers are essentially principal officers. And so the court said that we did not want a principal officer to invalidate the decision of the inferior officer. This is the similar case we have. We do not want a principal officer to pressure these judges because these principal officers could come as a party in front of these judges. And
Aren't you arguing one of the Edmund factors?
one of the Edmund factors? Yes. Edmund also listed that removable powers are essential. And here we do have removable power. There is definitionally, there is a superior officer above the principal, above the judges. So the part of my analysis where Edmund fails is when Edmunds talk about supervision, invalidation. That we just cannot have, practically speaking, like we did not have in Morrison, and the court still ruled that they were inferior officers. And for practical reasons as well. Like we mentioned, CDCA wanted this board to be efficient. They did not want the contractor to go to federal courts to make the litigation more approachable, faster, and inexpensive. And this is not just the CDCA, but we do also want contractors to have a faith in the system. If we have a principal officer who can invalidate the decisions of these judges, and that principal officer could be a party in the matter, the contractors would lose faith in the system, and we need the contractors to be a part, to have that kind of faith in this system for our government to function. For all these reasons, I would request the court to hold that these officers are inferior officers and they are rightly appointed by the GSA administrator. Thank you.
Okay, thank you. Let's hear from your colleague now.
Good evening, Your Honors. May it please the court. My name is Kalee, Odom, and I, along with my co-counsel, will be representing the United States government. I will be presenting the secondary issue of severability. While the government believes, of course, that the administrative judges, as you've just heard, are...
So with respect to this issue, how is this case different from Arthur's?
So in this case, Your Honor, there are certainly some similarities, but what we are arguing here today is that just as in Arthrex, there are provisions that can be severed in order to make the statute constitutional should the court find that that the board AJs are unconstitutionally appointed. And we have two provisions here today which we could sever. The first is 7107A1, and this is the provision which prevents the decisions from being reviewed. It's the finality clause. Now, in this, if we were to sever the finality clause, it would allow for a review of decisions made by the board AJs, and as such would alleviate some of the concerns brought by opposing counsel about an appointment clause violation.
Allow review by whom?
In this instance, Your Honor, we believe the GSA administrator. Now, there are three concerns when we're looking to sever a portion of the statute, as was addressed by my co-counsel. And for a statute to remain valid after severance, it needs to, 1, be constitutionally valid, 2, it needs to function independently of that severed portion of the statute, and 3, it needs to be consistent with Congress's basic objectives. Now, looking at the reviewability or the finality provision that we're discussing, in this case, it does meet all three of those factors.
So whose job is it to figure out how a reviewability by the GSA administrator would work and if it would be practical? Is that your job, our job, or someone else's job to develop? It sounds like there would be some layer of review after the CBCA has made a decision that would somehow go on to the GSA administrator's desk. So can you tell me who's in charge of figuring out how that would work?
Yes, Your Honor. So the Civilian Board of Contract Appeals, the CBCA, is currently housed within the GSA. As was brought up by Judge Hertling, It was explicitly established within the GSA by Congress, and the GSA administrator was established as the head of that institution. So in this case, Your Honor, it would fall to the GSA administrator to, in the due course of their duties, follow that review process. And, I'm sorry.
Is that the answer to my question? You're saying it would be up to the GSA administrator to determine how to go about reviewing CBCA final decisions?
Yes, Your Honor. In this case, because the statute does not explicitly include who would be reviewing, it would fall to the administrative officer at the head of the agency, presumably.
Doesn't that implicate the other argument, that is, would the CDA still follow the intent of Congress if you had discretion by the GSA administrator as to how to go about reviewing CBCA opinions? So for instance, and let me suggest something to you that might run afoul of the Congress's intent in the CDA. That is, if the GSA administrator didn't have a process but simply read CBCA decisions and had a stamp that said invalid or reversed and did that to CBCA decisions that he or she didn't like, wouldn't that run afoul of Congress's intent?
2 points to that, Your Honor. And the first, I would say that yes, specifically something like that may run afoul of Congress's intent. However, as a principal officer, the GSA administrator does report directly to the president, so there is a level, of oversight on that point. The GSA administrator could theoretically do a lot of things, but they are constrained by their responsibility to the president. And then looking specifically to the congressional intent of Congress when they were enacting this statute, they specifically wrote, and I believe as my co-counsel pointed out, that the CDA created the agency boards to adjudicate contract disputes, quote, to the fullest extent practicable, informal, expeditious, and inexpensive resolution of disputes. So Congress's intent was to do just that, create boards that could solve these disputes inexpensively, expeditiously, and informally.
Counsel, here's what I'm struggling with. Your colleague, Ms. Chhetri, argued that one of the distinctions between this case and what the Supreme Court addressed in Arthrex was that the PTO, and certainly the administrator there, is never a party to patent challenges, and so is a neutral reviewer of the PTAB's decisions. So the Supreme Court could comfortably strike the proscription on the PTO director reviewing the PTAB's decision. Ms. Chhetri distinguished this case from Arthrex by saying here the government is always going to be a party to the dispute. If we accept your proposed fix and allow the GSA administrator to review the CBCA decisions consistent with the point Ms. Chhetri made to distinguish this case from Arthrex, aren't we undermining Congress's goal of having an independent, neutral forum for the resolution of these disputes? And if that's the case, why shouldn't we just strike the whole system and send it back to Congress and let Congress decide how to rebuild a neutral forum?
That's a very fair point, Your Honor, and I think I would point to something the court said in Free Enterprise Fund. Specifically, they looked to essentially what the question was, is whether the board has reviewable decisions or is removable at will. Is that preferable, or would Congress have preferred that to having no board at all? And in this case, Congress has made clear that they want to have that board in place to have those inexpensive and informal resolutions of dispute, which contractors, just like Green and Clean, have been relying on since the board's inception. In fact, I believe it's over 200 contracts per year are taken to the CBCA. If we were to do away with that and send it back to Congress, those contractors would be left with only the option of ADR or taking it to the U.S. Court of Appeals for the Federal Circuit, which, as I believe several of your honors have pointed out, is a far more timely and expensive process.
If I can clarify, I think your opponents argue that the U.S. Court of cases would go if the CDA was invalidated, at least to the point of abolishing the CBCA or nullifying it. Do you know the volume of other cases before other agency boards, the Armed Services Board of Contract Appeals and the TVA and Postal Service, that would also head over to the Court of Federal Claims if those boards weren't allowed to do their work?
I don't have those numbers in front of me, Your Honor, but I'd be happy to submit a supplementary brief with them. But in this instance, if we were to force these contractors to take their claims to the judicial branch, not only is that a more timely and expensive process for them, it also puts them before a panel that is not necessarily as familiar.
Aren't you assuming that we would strike down the entire statute, just abolish the process? Can't there be severability of just the part of the statute that we need to cure?
Yes, Your Honor, that is what we are proposing here. We propose that either the reviewability provision, which we've been discussing, be severed, or the provision which provides removal protection for the board AJs.
Do you have a preference between those two, or an argument as to which one is more appropriately severed?
Well, we think both could be effective. The government does proffer the removability provision as a more effective solution, particularly because of the precedent before the court.
What do you mean that both could be effective? They could be effectively severed?
Yes, Your Honor.
So what would that leave? And would that leave the system still functioning?
Yes, Your Honor. It would, looking at either of the two provisions we presented here today and in our brief, with either of them severed, the second factor of the Booker test, the independent functioning, would still be met. With the reviewability, the board would still be perfectly capable of completing their duties if their decisions were reviewable. There'd be no change in the civilian board's capacity to make those sound decisions initially. The only difference would be that with the severance, of course, the board decisions would be reviewable. Their initial capacity to make those decisions would be unaffected. And it's the same with the removal provision. Looking at the removal provision, the board would still be more than capable of completing its duties. Should the removal protection, provision be severed, as can be seen in, as Your Honor brought up, several other boards, including the Armed Services Board of Contract Appeals, which is a board that was created simultaneously without these removal protections and has been functioning independently of them since its inception. Now, with either of these, we must focus on ensuring that the remainder of the statute is constitutionally valid, independently functioning, and fitting with Congress's basic objectives. And in this case, both of them would be. Looking specifically at the removal provision, as Your Honors asked which would be preferred, without the removal protection, the administrative judges would be removable at will, which, as opposing counsel pointed out, is a strong tool for control, as was mentioned in Arthrex. And allowing that removal protection, allowing the board AJs to be removable at will addresses a lot of concerns that there may be with the appointments clause. Now, specifically, they would be removable at will by their appointee, who is, of course, the GSA administrator. And the GSA administrator, as Your Honors know, is a principal officer within the executive branch. So their ability to remove the board AJs at will would be sufficient with the other factors discussed by my co-counsel to ensure that these officers are, in fact, inferior officers and are therefore constitutionally appointed.
Well, let me see, are you 100% confident in that? That is, if we severed just the removal provision, would the structure of the CBCA still be able to withstand a challenge that then suggests that the non-reviewability of their decisions still make it unconstitutional?
We believe so, Your Honor. Looking at the precedent that the court has put forward, there are several cases, including Free Enterprise Fund as well as SELA law, as far as binding law goes from the Supreme Court, which show that removability is sufficient in determining whether or not the officers are inferior. And in a non-binding case by the DC Circuit Intercollegiate Broadcasting System, the same conclusion was met. So in that case, Your Honor, yes, we do believe based on precedent that severing the removability protection is sufficient to make the officers inferior or ensure that they're inferior.
Well, so I understand both arguments, the reviewability and the removability that you're making. It seems to me that if we're trying trying to preserve the independence of the board to the extent possible while still making their appointments constitutional, that the removability provision is the one you want severed.
Yes, Your Honor.
That it's not having their decisions immediately reviewable under procedures that, as we discussed earlier, no one knows, is much more of a threat to the board's independence than simply having them capable of being removed at the will of who appointed them. Do you agree with that?
I'm so sorry, could you clarify the last sentence of that?
Well, that the removability, if you remove the removability protection, that will compromise the CBCA judge's independence less than if you make every decision that they write immediately reviewable by the head of the agency.
Yes, Your Honor. We certainly agree with that. Specifically, given the fact that, as I mentioned a moment ago, the Armed Services Board of Contract Appeals has been functioning under exactly that structure and is still perfectly functioning, Your Honor.
So you're arguing that the severance of either or both of the CDA provisions is preferable to no severance at all. And one of the reasons is because of the service that the board provides to the contracting community, correct?
Yes, Your Honor.
And so your fear is that that structure, that goodwill that's built within the contracting community will disappear.
Yes, Your Honor, we worry
Why
that.
should we be concerned with that if what we're really faced with is a unconstitutional statute that takes more than 2 strikes of the axe in order to sever and to be able to cure correctly?
Your Honor, I think both of those things can coexist. We can be concerned with wanting to ensure that our contractors are comfortable contracting with the government, as so much of our system of functioning is based on these contractors. But at the same time, we do believe that severing these provisions, or one or both of these provisions, is sufficient to make it constitutional. So we're able to address both of those concerns. And we want to do so as narrowly as possible. We want to take a scalpel to the...
So the remaining, that which remains is constitutional, and that's enough to ensure the continued functioning of the process?
Yes, Your Honor, by ensuring that the statute is constitutional, functioned independently, and I see my time has expired, may I briefly?
Yes.
By ensuring that the statute is constitutionally valid, functions independently, and functions as Congress intended, that is sufficient to meet this court's 3 requirements for Booker.
Any other questions? Okay, we thank you for the argument.
Thank you, Your Honor.
Janet, you have 2 minutes, so we will.
Thank you. May it please the court. My rebuttal is twofold. Opposing counsel mentions the practical considerations of patiently invalidating the Contract Disputes Act and removing the Civilian Board of Contract Appeals. However, there are ways to alleviate these practical considerations. First, interest parties still filing at the Court of Federal Claims. Potentially, the Court of Federal Claims could temporarily waive fees to reduce the expensive process of filing there. Or judges could continue to...
Can I ask you a question?
Yes, sir.
You're talking about invalidating the CDA, and you are resisting the notion that offending portions of the CDA would be severed. Are you saying that we should invalidate the entire CDA, as in even contracts can't be written or awarded or performed?
No, Your Honor. I'm just arguing that the provisions as to the Civilian Board of Contract Appeals should be severed.
So you're saying you want us to sever something short of the entire CDA?
Oh, excuse me, I apologize. I'm suggesting that the entire Contract Disputes Act is facially invalidated. Along with that, the Civilian Board of Contract Appeals is invalidated.
And doesn't that mean that all contracting officers in the U.S. government cannot sign their names to a contract tomorrow?
I'm not aware of the Contract Disputes Act stating that. I apologize. I can provide a supplemental brief if it does state that that contracting officers
Isn't the Contract Disputes Act the backbone by which the U.S. government conducts all of its business?
Yes, it is, Your Honor. I would be suggesting then that the contracting officers would be unable to do so. In the meantime, Congress should be left to fix the unconstitutional violations of the statute. And I see my time is shortly expiring. For the foregoing reasons, respectfully I request the board vacate, remand the decision.
So you're suggesting, counsel, that if we follow you down the path you're leading us and accept your argument, that the day after we issue a ruling in your favor, contracting officers at the Pentagon will not be able to buy ammunition to support U.S. troops currently in the eastern regions of NATO? Is that the effect that you want us to impose on the United States government?
It may be an effect that, yes, Your Honor, it may be an effect that results from invalidating the Contract Disputes Act in the name of this constitutional violation. Yeah, yes,
Mr.
Your Honor.
Figuenick, are you familiar with Justice Jackson's comment that the Constitution is not a suicide pact?
I'm not, but thank you for your comment, Your Honor.
Thank you, counsel.
Okay, we've heard the arguments, and we'll take this case under advisement. No. And we take this case under advisement, and this court now stands in recess. Question to the organizers, do we provide comments now, or do we come back?
It's whatever you prefer, but generally,
We
you
come
go
back?
out, you deliberate, and
Okay. We'll be back in a few minutes with comments.
This honorable court is now adjourned.
all right. That was a hot bench. So they're gonna deliberate. Stuart, do you want to just go waiting outside? Let them, when the time's up, they can come out. In the meantime, this shouldn't take very long, so please help yourselves to,
Some liquid death?
yes. And the Arnold and Porter reception will start after this. It's, at the Eden Hotel Salon Rooms at 1201 K Street. If you're driving, they notified me today that they're covering validation, so, there's that. And, and for, the competitors, after they come in and, share their updates and feedback, we ask that the competitors stay behind, for some group pictures, and then everyone else can, if you're going to the reception, please proceed to the reception.
Professor, just these competitors or all competitors?
Just the finalists right now, so.
I'm sorry, just to clarify, you're sending everybody to the reception now?
No. We're waiting for the judges to come back to, make the announcement and the feedback. I mean, I guess you're free to leave whenever you want, if you don't wanna stay for that, but.
Still sweating. Nicely done. I'm still like, I just can't get over the noise. In your I also appreciate you.
I couldn't, once I got there, I knew the rest wasn't going.
Yeah.
That was amazing.
Really? It's amazing?
Amazing in the sense that those questions were amazing.
Yeah, they were great questions.
Yeah, really makes me wonder.
Yeah, they did.
I'm sorry you missed it.
Yeah, we pulled out that Justice Jackson.
And the tour was like this and that.
Wait, so what's
It was like the coolest. And I was
so was your solution actually really actually to
yeah, it was pretty Oh, yeah.
He was just coming down on the
I was so ready for
It's just a transactional cost. In my life, on my first class.
Please have a seat. After much concerned and pronounced deliberations, we determined that the winning team are the appellants in this case. You know, it's always good to get to win, but if there's ever been a difficult decision in a tie or something like that, this was it. I mean, you two did a superb job in arguing your cases. There were slight differences that we saw in the arguments, and we were persuaded differently. But I like to say that I thought that the appellees were superb in their aggressiveness, in your ability to protect your position, and you protected your positions very well. You know, I tried to rattle Miss Chhetri, and I don't think I did. You know, she's a tough litigator, and I thought that you did a superb job. And Miss Odom, you had a good command of the case, of the facts, and you just appeared very relaxed. I mean, normally I see the students that are just shaking at the knees, you know, but you were very relaxed and very poised and everything. So as to the appellants, Mr. Gardner, you did an excellent job in your delivery, and it's clear that you mastered the facts well and understood the arguments and were able to put them across in a very simple way, and you need to do that. I mean, oftentimes litigators think that judges are looking for complexity. We're not. We don't want it to be complex. Things are complex enough as it is. The problems are complex. The regulations, the cross-indexing, all of that is difficult. We want the litigators to put it in simple terms so that we can understand it and reach a just decision. And Mr. Gardner, I thought you did a good job in doing that. Mr. Figuenick, it seemed to me that you got lost a little here and there in your argument, but you came back well, and you not only survived, you persevered, which is good. I mean, you didn't melt. I've seen that happen too. You hung in there, and this is where I think there existed a balance, and we can't come up with a tie, but if we could, this would be one of those situations. And all four of you did an excellent job, and I look forward to seeing you in my court sometime and representing clients. I think clients would, I think we can say that in terms of government contracting, our country stands in good stead when we see young litigants like yourselves being able to present the type of programs and arguments that you did. I was impressed with all four of you.
One of the privileges that I bring to this competition is that I worked for the Justice Department for almost 15 years and got to present arguments much the way you both teams just did before both the Court of Federal Claims and the Court of Appeals for the Federal Circuit. And I'm not sure my colleagues here shared that honor to be able to essentially do what you did in the real world. And I commend you for your ability to do that. I think this problem brought different challenges to both of you. The appellants had to advocate for a suicide pact, as Judge Hertling mentioned, and that is certainly a skill that is difficult to do, in that sometimes you have to say, yes, that's what we are advocating, or yes, that's going to be the effect of you ruling in our favor. And I thought you handled that well. You conceded when you had to. And one of the worst things a lawyer can do is to essentially refuse to concede anything. And so you've developed that skill early in your career, so congratulations on that. Do you guys do this for credit, or is this an extracurricular?
No, it's 4 credits, a 2-credit course.
Okay, good. You've earned it. You too, and Judge Reyna is correct, that if we could have called this a tie, we would have. And it was very close anyway. And your challenge on in this problem was more to kind of figure out how to press what I consider to be the substantive advantages that you already have. And you did that well. You kind of read the bench, and you could sort of see which one of us were trying to challenge you versus which one of us wanted you to kind of push your advantage even further to either create a record or convince the other judges on the bench. So I thought you handled that well, and the comment, Ms. Odom, about you having a lot of composure, that is true, and that's a valuable skill to be able to calmly respond either to a challenging question or, as I said, to one that asks you to keep rolling the barrel down the hill. So nice work to both of you. Congratulations.
And I will try to be brief. So, Mr. Gardner, I thought you did a very good job. You had, as Judge Reyna noted, good command of the facts and a very good command of the various lines of precedent. And you understood what parts of the precedent to rely on and what parts you needed to dance around and distinguish away. And I thought your mode of presentation was very strong. You were confident. You spoke clearly, slowly enough that we could get the import of what you were saying. One little tick that I noted, you consistently started your answers to almost any question with, "Yes, Your Honor." You don't mean to say yes to every question we asked, and that's just kind of a little nervous tick. You'll overcome that, but that was one thing that if any of us tried to get you with a bad precedent or a bad fact, and you said yes, Your Honor, which made it sound like you were starting to agree with us, when to do so would have undermined your case. But otherwise, I thought you did a very nice job. Mr. Fazenic, I thought you were less poised in handling the questions. I think you came perhaps a little too dug in with the points you wanted to make. You had an approach that you were going to bulldoze your way to getting your points across. And sometimes judges don't let you do that. And I thought when we kept pulling you in different directions, you were less adaptive. When we sat back and let you get back to the points you want to make, you were quite effective. but I think you need to come into these things understanding that judges don't have the same agenda. They may not see the case the same way you do. And you need to be prepared going forward in oral advocacy to adapt a little bit. And that's a skill that you're just gonna learn as you do more arguments and you get more comfortable in front of judges. But don't come in with, with bullet points and not a speech. Ms. Chhetri, I thought you did a very nice job. I thought your distinction with Arthrex, that the government's never a litigator in the PTO, before the PTAB, and it's always gonna be a litigator here, was very effective and spot on. It was the key distinction that I had come up with, and I was very impressed that you came up with it. I thought you were a little less effective than in explaining why Edmund, in which the government was always litigating on one side, didn't though compel a finding that the AJs on the board are unconstitutionally appointed. But overall, I thought your presentation was very strong. You were composed, you didn't get thrown, and you hung tough on your argument, even when we were pushing you to try to concede. You didn't concede things you didn't need to concede. So I thought you did a very nice job. And Ms. Odom, I'll just reiterate what my colleague said. I thought you were extremely poised. You also had very strong command of the facts and the cases. You had them, and you had quotes at your fingertips. And for myself, I would say of the four of you, you did individually the best job of the four. But overall, I think because the appellants had the higher hill to climb, overall I thought they did a slightly more effective job. But it was very even, and I thought all of you were extremely well prepared, very, very grounded in what you needed to do, and as you get more practice and more comfortable doing what you're doing here, I'm sure you'll all be exceptional advocates.
Let me make another general comment here. And this doesn't necessarily apply to your performance tonight. It's just a hint. And you have three different judges here, and we all come from a different court, a different body, a different forum. And when you come to my court, you will see a panel of three judges. And that's what this moot court is about, being before the federal circuit. So you have three judges to convince. And during your argument, while questions are being asked to you, the court is letting you know what's bothering the court, where the questions are, but more importantly, it's letting you know where you can win. It's letting you know where you can throw the lance. And so keep that in mind, that the three judges, sometimes we don't know how the other judge is going to rule. And sometimes during oral argument, I find out for the first time that Judge Smith is going to rule this way. Well, if I'm going this way, I may start asking you questions to divert you back into, to educate him, so that he can hear the answers and I can change his mind during the course of the litigation. So the astute litigator is listening to the questions very, very closely that the judge is asking and addresses those questions. One way you can tell that this is going on is, and it's a very simple, practice pointer, but call the judges by their name. You can say something like, instead of saying, yes, Your Honor, and that was a good point. And I heard other similar type of manners of addressing the court. But instead, if you're listening to the judge and you go, Judge Reyna, the CDA, and then you go on with what you're saying. Now, you call me by my name, just like I call my puppy by his name, he's gonna turn around and look at me. Well, you know, call the judge by his name, and that way you can start working your way within the mix. And now Judge Smith will have you engaged in a conversation, and halfway through it, you're ready to swing out of there. And then you go, and as Judge Reyna was saying, and now you've got me engaged, and you're on your way. And so you can't do that. You can't do any of this unless you've actually have mastered the record as a litigator. I as a judge master the record differently than I did as a litigator. Totally different. You know, I'm looking at points of law. And at the Federal Circuit, we are looking at, this is going to the Supreme Court next. You know, so keep that in mind. The court that you're in, the judge that you're before, and then what is it that the court is telling you that, how you can win your case, and then get yourself involved in the mix of the discussion that's happening here on the bench, not just necessarily there back and forth, okay? And if you do that, I think you all will do it. Yes, sir, Professor.
If the court would briefly indulge me, first, on behalf of the group, I would like to thank the judges for their spirited and excellent pressing of the students, and I really appreciated the fact, and I hope the students saw this, that you weren't permitted to do a monologue at the beginning, which I find quite common in the Federal Circuit. So first, thank you for your time, thank you for your preparation, thank you for your energy. I also want to congratulate the competitors in the front of the room, but everyone who participated. But I also can't, because I am who I am, pass up a wonderful teaching moment that we saw at the end of the argument as Judge Smith led the competitors down what I might call a path possibly off a cliff. And it exposes one of the complexities of any issue and the fact that sometimes in an oral argument, you may open a door to something that is not before the court is not prepared for, and the court may not know the answer to. So, Judge Smith asked about the contracting officer. Well, the timing's hysterical, because at the law school, we teach formation of government contracts in the fall, authority to enter into contracts. We teach performance in the spring, and it just so happens we haven't gotten to contract disputes yet. But the interesting thing is, you could blow up the Contract Disputes Act of 1978, which is in many ways independent from the authorizing statutes in Title 10 and 41 that lead to the creation of contracts. But again, there's no reason for you to know whether the judges know that and whether the judge is baiting you or taking you off a cliff or leading you to an absurd conclusion. But back to Judge Smith's point earlier, when you're preparing for an oral argument, one of the hardest things is realizing where it might go that has nothing to do with the record before the court. So I thought that was fascinating, but again, congratulations to the competitors. Thank you so much to the judges.
And one point to follow up on what Judge Reyna said, you have to know what court you're appearing from. Right? In my court, I sit alone. And you know when you get a case filed, when you file a case in my court, you know the judge to whom it's assigned. And that case is gonna stay with that judge throughout the litigation. But if you're going to be in front of, say, the Federal Circuit, you're not gonna find out who the panel is until you're there for argument. And so you can't war game, okay, I'm gonna play to this judge because I know she's gonna be sympathetic. You just have to master the record, master the law, master the points you want to make, and as I was saying earlier, you then have to be adaptive, because when you show up in Judge Reyna's court, you may draw a panel that is really good for your case, based on the way the members of the panel have ruled previously, or you may get a panel that could be very bad for your case. And you're not going to know that till the end. You can't figure that out. You just have to master your case and let the rest take care of itself.
Well, we thank everybody, and we thank you for the opportunity.
On behalf of the government procurement law program here at GW, once again, thank you so much, judges. We just have a little token of appreciation for you all. So, thank you everyone for coming, finalists, and